Thank you for taking the time to be here today. Thank you for your interest in this topic that is very important to so many. And thank you for Elaine and everything that she's doing through Families Divided. And thank you for the opportunity to educate and to contribute to this conversation that is so important to the question of how we move forward in this, not only state to state, but as a country, as it relates to the relationships between parents and children. And so when I was asked to speak and we were looking at topics, that there was one that has been on my mind a lot. And as many of you know, if you've listened to any of my presentations, you know that I like to talk about things that are close to me, or they're fresh in my mind, or there's something that I'm seeing more within my practice. As a family law attorney in Oklahoma, we have a lot of exposure to all kinds of issues. And so I like to talk about the things that I think we're seeing more and more of. And so when asked what I wanted to talk about, the topic that I came up with was obviously a parental alienation topic, but there's plenty of blame to go around. And the premise of that is that as we are talking about parental alienation and as we're looking at the issue, there is clearly more than just the alienating parent that may bear some responsibility for what we're seeing. And I want to talk about that and talk about what the issues are. I want to identify the issues, and then I want to talk about what are some solutions that I think are practical and are pretty easy to implement. And then, kind of what I foresee as we move forward in this conversation. And so, first of all, I think it's very important when we're talking about anything in terms of parental alienation and parents and children and the relationships between the two. We have to have an endpoint or an idea. As Stephen Covey would say, we need to begin with the end in mind and ask the question, what is the ideal end for any prospective two-family home? Obviously, in an ideal world, families would stay together. I think that is the best option for children if mom and dad are both in the home and they're in a healthy relationship with one another. But if that isn't the case, and we know that in the majority of marriages today, this is an issue that's going to come about, well, then we have to start looking at what is the best outcome if they're not going to stay together. If a husband and wife are unable to remain together and they must divorce, ideally, I think we would agree parents would share in the time and the relationship with the children equally. So let's state that is our starting point. That's our end that we're looking for. And it's clear that it's in the best interest for the parents to share in the upbringing of their children, as we see more and more and more literature that has been studies have been conducted. The academic world is adopting a real belief now that moms and dads both impact the lives of their children, and it's better for parents to have relationships with their kids, and it's better for the kids to have relationships with both parents. There's one study that I've cited to often that talks about the ideal visitation schedule or parenting time schedule is one which the children have the opportunity to interact frequently with both parents. And that's going to require that the parents and the children be involved in various activities and functions such as meals and playing and discipline and the basic care for the child, setting up limits and boundaries, putting the children to bed, getting them up, brushing their teeth. All of those things are very, very important in terms of the process. And so if you're going to have equality, then both parents need to be involved in that. And it doesn't need to be just donuts on Saturday for dad. There is an emerging consensus developing, and really, I think we can say it's developed, that at a minimum, parents and children need to spend at least 1/3 time together, and that the benefits of that time increase as you get to 50-50, and that ideally Literature suggests that 50-50 time is ideal. Even in high conflict cases, I can cite to literature that supports the fact that time with both parents is critical. And even in a high conflict case, you can get to the point where there's equality there as it relates to parent and child. And so that's where we want to set our goal, and we want to set our marker, that we want to get to that place where if you're going to be in a divorced family, the children have equal time with both parents. And that's why in our practice, I think it's sometimes chic to say you're a dad's rights attorney or you're a mom's rights attorney. What we really stress the fact we're parental equality. When we are a equal parenting firm, where we think that every parent matters, both parents matter is a slogan that you're going to see on some of our material. And it's because we believe that moms are just as important as dads, because we believe dads are just as important as moms. And so if we're going to start in that place, then that's where we're working toward. This isn't the case, though, in many instances. And that's why we're here today. That's why we have a conference such as this. That's why you're seeing this topic become front and center in a lot of arenas. Too often, one parent goes into this divorce process or custody process attempting to limit the other parent's time with their kids. They may start with, I want to limit it to every other weekend. I want to limit it to no time. They may come into it very ambitious with their request that they just want the other parent to go away. And that seems to be more common than the alternative of just, I want equality. I want equal time. He and she can have equal time. And so knowing that that's where we're starting in this process, we then start moving to this place of what is parental alienation. You've heard a lot, you're hearing a lot in this conference regarding what parental alienation is. You're hearing about what solutions are out there, how to combat it. As a practical practitioner who is in the trenches on this issue, I'm going to let you know what I think parental alienation is. I define it as a parent's strategy to intentionally display to the child unjustified negativity aimed at the other parent, with the intent and the purpose to damage that child's relationship with that other parent, even turning that child against the parent. So I kind of take it from the perspective, just real practically, that's the verb alienation. And we're going to talk about verbs and nouns, but as far as the verb parental alienation, that's my definition. There is a case out of New Hampshire. I'm happy to cite to it. There's a case out of New Hampshire that just has, I think, one of the best paragraphs as it relates to this issue. And I want to start there because as a practitioner, as an attorney who is going to be advocating on behalf of a mom or a dad who the other parent is trying to keep that parent away, obviously, anytime you can cite to a case that has adopted a parental alienation ruling, you want to look at it. So in this case, it's In re Miller. It's out of New Hampshire. It's a 2011 case, and I'm going to read it. And so it says, across the country, the great weight of authority holds that conduct by one parent that tends to alienate the child's affections from the other is so inimical to the child's welfare as to be grounds for a denial of custody or a change of custody from the parent guilty of such conduct. So that's the first sentence. He goes on to say, a child's best interests are plainly furthered by nurturing the child's relationship with both parents, and a sustained course of conduct by one parent designed to interfere in the child's relationship with the other casts serious doubt upon the fitness of the other offending party to be the custodial parent. As we have recognized, the obstruction by a custodial parent of visitation between a child and the custodial parent may, if continuous, constitute behavior so inconsistent with the best interests of the child as to raise a strong possibility that the child will be harmed. Okay. that's the paragraph. And again, if you want to reach out to me, I'll give you the citation. I want to start and I want to deconstruct that just a little bit as we start, because I think it's very critical to this conversation, because you're seeing a lot of the alternative narrative that parental alienation is junk science. There is no such thing as parental alienation, and that we are, the conversation we're having is just either a political conversation or it's a conversation based on some ulterior motive. And that's the counter narrative to what we're talking about. But this court so wisely identified the fact that parental alienation is not, we're not talking about the noun. We're not talking about a syndrome. We're not talking about something that has to be in the DSM. And I think we get so wrapped around the axle and so lost in the conversation about parental alienation syndrome is junk science that we lose sight of the fact that parental alienating behavior is recognized, it's real, and it's been recognized for generations as we have gone through the family law process. And as our family law codes across the country have been revised, there has been more recognition of alienating behavior. And I think you're seeing that if you look at your codes. And in this case, this court says the great weight of authority holds the conduct by one parent that tends to alienate the child's affections from the other. That's the verb. So it's the alienating behavior that is the issue. And then if you're a parent who is going to act in such a way that's going to alienate a child from the other parent and try to divide and distance that child from the other parent, then you're not fit to have custody of that parent, that child. That's what this court's saying. And I think it's critical in all of our courtrooms that we get away from this narrative of, well, parental alienation syndrome. Get away from that. You can even stop using parental alienation if you want to. Divide and distance, because what a parent is truly trying to do here is to divide and distance that child from the other parent. Whether you call it parental alienation or whatever you call it, it's an effort to try to distance a child from the other parent for whatever reason. You've heard me talk about various motivations, whether it's theological, whether it's power and control, whether it's just simply a child support grab, whatever the motivation is, it doesn't matter. It's just an effort by the other parent to try to keep that child or distance that child from the other parent. This court wisely ruled that a child's best interests are plainly furthered by nurturing the child's relationship with both parents. And a sustained course of conduct by one parent that's contrary to that is not in the child's best interest. And so that's where I want to start us in this conversation. Because when we talk about parental alienation, I'm not talking about a syndrome. I'm talking about actions by the other parent that are so they're egregious. They're attempts to try to distance that child from the parent and to keep the other parent away. And that could be something. And I think that in due time, we're going to look back and realize that our standard visitation schedules in this country in most states are egregious to give a parent two overnights every 2 weeks with their kids, just because that's what we call the standard. That's egregious to me. And so just that simple act of saying, well, I want standard visitation, that's an effort to try to distance or to divide a parent from the other. That may not be defined as alienating behavior, but it's defined as trying to limit parents' time. And so if we start there and we start the conversation by showing that just limiting that time and treating a parent unequally, that's the problem. Okay, so back to what we're looking at. There's plenty of blame to go around. I'm going to take you through a very practical conversation about how, as an attorney, some of the things we're going to look at along the way. I'm going to identify every player in most of these cases, and we're going to talk about how they contribute to the process, whether it's good or bad. But we're going to talk about the stages of the case. We're going to talk about some of the solutions. Okay, so that's where we're going to go over, the next 40 minutes or so. early stage of the case, the early posture of the case is so incredibly important because the early stages are incredibly precarious. During that initial temporary order period, so you file a case and there's a period of time where there's no set order as to what visitation is going to be, and that's where you really start to run into a lot of the initial issues in a case. Are there going to be allegations of abuse? Are there going to be efforts to try to keep the children away from the other parent, from the target parent? Is this the case where the case is going to go? So during that temporary order period, when you're starting to set that visitation schedule, so critical, because if you don't obtain equal time between parent and child at that early stage, there's a greater chance that alienating behaviors are going to succeed, because the alienating parent's given the opportunity to isolate, to divide, to distance the minor child from the other parent. So very first step needs to be to try to establish a desire for equal time. If your state has a presumption for equality, that's a great place to start. Okay. So in Oklahoma in 2021, we passed a law which strengthened and improved our expectation for equality with access. Okay. So in Oklahoma, we have a statute that states that if you can't show reasons why, whether it's abuse or issues that are going to be harmed to the child, then both parents have an expectation of equality as it relates to their time with their kids. We're going to talk about that and how that gets applied, but at least we start from that perspective. And if you have a statute that gives you that presumption of equality, start there. Now, that's where you're going to start seeing allegations. Maybe you come in early on with a VPO, which we're going to talk about. Maybe there's the other side files for protective order. Maybe they're making allegations of abuse. Maybe they've filed a police report. Maybe they've taken actions to try to posture the case so that they don't have to share in visitation and parenting time. You're going to have to combat that. You're going to have to the problem whether it's a problem or not, it's up for debate. But because a parent can make any allegation they want at any point in this process, it's up to our system to try to protect against false allegations. It's also up to our system to protect victims who are legitimately abused. And so we're going to talk about that. But the ability of a parent to alienate can occur as a result of an unreasonable delay in maintaining an unequal parenting relationship, an unequal parenting schedule, by manipulating. Manipulative parents have a better opportunity to brainwash and manipulate a child as a result of one-sided influence. That's clear. There's clear studies and support for that. So if they're unchecked, they're going to have an opportunity. So this is where, as the attorney and as the litigant, we have a responsibility of trying to get that case in front of a judge as soon as possible. Delays are the worst in parental alienation cases. You can, and we're going to talk throughout this entire discussion. We're going to talk about how delays feed. They're kind of like the food for a parental alienating parent. A delay is just going to be music to their ears. So you want to expedite, and you need to be able to expedite getting in front of the judge as quick as possible. Because if you don't, there's going to be more time for delay, one-sided conversations with the other child, influence, and manipulation. If you do get a domestic violence allegation and you get an allegation of abuse, you have to address that strategically. Okay. So a lot of attorneys will not allow their clients to testify in a VPO case because it's quasi-criminal, but it also, in a victim protective order is what I'm referring to. It's what we call them in Oklahoma. Some states call them other things, but what we're talking about is when a person makes an allegation that the other party, the target party, abused them. There's domestic violence of some sort. The reason that's so important in a family law setting is that Oklahoma, and that's what I'm going to talk to from experience, but many other states have presumptions against perpetrators of abuse. So if a court finds that you're a perpetrator of domestic violence, there may be a presumption against you having custody of your children. There may even be a presumption against parenting time. It's definitely going to be an obstacle that you're going to have to overcome. Also, and I was just talking to a judge this morning about this issue at the time of recording, but in Oklahoma, if the court finds you're a perpetrator of domestic violence, there's not only a presumption against custody, but there's also a mandate that you're responsible for attorney's fees in the case. Okay, so reasonable attorney's fees, there's a mandate. Okay, so allegations of domestic violence are becoming more and more common. I spoke to a judge this week who said that they are seeing them in so many cases, more cases than they can remember. And part of that is because we have created in Oklahoma a presumption that domestic violence allegations should lead to this presumption. And if you can establish domestic violence, not only do you get custody, but you get your attorney's fees paid for. So it is used as a sword throughout our process to make allegations of domestic violence in family law cases. It creates a substantive advantage in the case if you do make the allegation. Okay, so practically speaking, an allegation of abuse in your pleading puts a party on notice that they're potentially on the hook for attorney's fees and in custody. So there's now a financial risk to that person even pursuing their case, even going in and asking for joint time, because they now, if they lose and there's a finding in domestic violence, they have to pay attorney's fees. Additionally, and oftentimes you don't get an opportunity to even get to ask for joint time until you get a trial in the case. So you're going to incur a lot of fees leading up to that point. And so it really, a domestic violence finding is a very significant allegation in our cases here in this state. An allegation of abuse that's well presented, it's hard to defend because a lot of times it's he said, she said, and we know that. And we're seeing a more emotional abuse allegations. We're seeing more power and control allegations. We're seeing more allegations of financial control. We're seeing all of these domestic abuse allegations that are taking various forms. And if you don't have a court that's going to really test those allegations, and they're going to just simply take whatever is said by the party who's making them, you're in for a long case. It's going to be a very hard case to litigate. It's going to be a hard case to win, because if you're up against false allegations of abuse, that's going to really kind of dictate everything in that case. So get your case after it's filed. You want to get it heard as quick as you can on a temporary order basis. You want to guard against any domestic violence. You need to get control of your client. If you're the attorney, if you're the client, if you're the litigant, you need to watch your P's and Q's. You need to document everything, make sure that you've got everything laid out in terms of documentation. You need to take photographs of everything so you can document where you were and when you were there, and make sure that you're protecting yourself, because it's the reality of the world we live in. Those allegations are being made more and more often. All right, so what else besides domestic violence allegations? Court schedules and docket management have become in Oklahoma especially, our dockets are so crowded. I know a lot of states are seeing this as well. Our dockets are so crowded as cases become higher conflict cases and they stay on the docket longer. It's leading it to more docket crowding, and it's making it harder to manage dockets in some jurisdictions, and that becomes a due process issue. I was thinking about the due process term. I check due process a lot in our cases. I many years ago I had a case involving an allegation of abuse, and the court took a parent's child away, and I had the opportunity to work with an out-of-state attorney, fairly prominent family law attorney in the country. I remember them coming in and making the argument, just argue due process, due process, due process. And it stuck with me because it was something I had never heard at that point. I've been practicing probably 5 or 6 years. It was something that I had never heard up to that point, due process in the family law setting. But it's something that I think, lose sight of, is that when a relationship between a parent and a child is a protected interest, it is a constitutionally protected interest. No different than someone coming in and taking your home away, no different than someone putting you in jail. Taking a child away comes with certain due process protections that should be protected at the highest order. So as we're talking about dockets and court schedules, and we're talking about how this impacts this issue, I want to point to, in Oklahoma, our Supreme Court in 2006 case addressed this due process consideration. And what it did, the case in question applied a very clear standard that due process applies to the time involved in getting your case heard. In this case, it was piecemealing trials. In our jurisdictions, in our state, a lot of times you'll start a trial on Monday and Tuesday. If you didn't set that trial for a long enough time, you may get pushed off and finish 3, 4, 5 days, months from now. Okay, so the Supreme Court came in and said that, holding a divorce trial in a serial fashion, piecemeal over the course of a year, implicates fundamental fairness questions, due process questions, right to speedy and certain remedies questions. And it applied those things to our family law cases in a way that hadn't been really done before. Postponements in the course of a trial is not favored, and that it really depends on the circumstances. And if you are a litigant who's contributing to those postponements, you're not going to get that protection. But if the circumstances warrant, then you may have a due process claim that your case isn't being heard fast enough, that you are being deprived of your relationship with your children without due process. If the kids have been taken away and you didn't have an opportunity for a true hearing, and you're not getting an opportunity to have a speedy trial on that issue, that's an issue. Okay, so court systems, and what I'm saying here is not judges necessarily. It's not even a criticism, except for the fact that if we have overbooked courts, and we have dockets that are too large for our courtrooms, and we have too much going on in our family law courtrooms within various jurisdictions, that can contribute to delays in the case, which can contribute to parental alienation conduct, which allows for children to be brainwashed and influenced by that alienating parent without an opportunity to have a hearing on whether or not that should be the custody order. So the due process consideration is one that has to be argued, but in terms of the blame to go around in this instance, courts have to be conscientious of their docket management and making sure that if you've got a custody question here, you need to more timely set that and have these hearings. And that's a hard issue, and it's one that we deal with in a lot of cases, and a lot of attorneys deal with those issues in a lot of cases. And if you aren't able to move your case along timely, then it can contribute to that alienating behavior having an impact. That's where we go from alienating behavior to alienating syndrome, because that alienating parent was given the opportunity to do so. And so you really have to move that along. That leads us to the next issue of judges. They're in control of their dockets. They have to be mindful of this, but they are overworked. Their staff is overworked. The increased volume of high conflict cases has really done a number on the judicial dockets, and so judges have to be mindful of that and conscientious of that, and try to contribute to it. Judges also are going to have to acknowledge that parental alienation is a reality. Alienating conduct is a reality. And we're starting to see this more and more as generations of new judges start to come in, and they've heard this term and they grew up with this term. But if judges deny that alienating behavior occurs, or if they turn a blind eye to it, then they are contributing to this behavior themselves by not holding a parent accountable for that. If they don't want to hear about it, if they don't want to listen to it, if they don't want to give it the attention that it deserves, then they are contributing to that conduct. It's so important that they take that into account, because if they are allowing it to happen and they're delaying it, then it is contributing to this parental alienation. I'll tell you something that's been really interesting to watch is that there have been, as we have been dealing with border crisis issues on the southern border of the United States, there's been a lot of study and comment and literature about the impact on children being separated from their parents. And if you have a judge that is not listening, there is a lot of new stuff out there that you can utilize. There's a 2020 study out that concluded that parental absence impacts cognitive and academic well-being of a child. Short-term and long-term educational outcomes were impacted by parental absence. Well, that's what we're doing here. We're taking a child, we might be taking a child away from a parent without that child understanding or knowing why. And if that's happening, that court needs to know the impact that's going to have on those children. There was a Stanford study recently that examined early life trauma and stress, and that confirmed that family separation is a trauma which affects brain development in children. It impacts children's psychological well-being. So if you're a judge and you're not acknowledging the impact that taking a child away from a parent is having, then you're ignoring the data, you're ignoring the science that's coming to light as a result of a lot of organizations who would not consider themselves equal parenting organizations, probably would not consider themselves on that end of the spectrum, are coming out with a lot of research and literature on the fact that parent-child separation has long-term effects on child well-being. And even if there's a subsequent reunification after being separated, reunited children are experiencing difficulty with emotional attachment and self-esteem issues and physical and psychological health issues. That's a study from 2017 that came out that found that that's happening. And they're using the border experience and the separation of parents and children at the border as their research tool. But the same thing is happening in our courtrooms when we're taking children away from parents when they have a strong relationship with that parent. There's no basis for anything happening other than equal time with both parents. So be mindful of that. And as judges, if you get a judge who isn't going to listen, you get a judge who isn't going to acknowledge that alienating conduct happens, if you're getting a judge that does not think that the father-child relationship is important, or that even the mother-child, or if you just pull a child away, children are resilient. We hear that all the time. Children are resilient. But yes, they may be resilient, but they also are being impacted by being away from mom or dad. And that is something that our judges have to take some responsibility on. And they're following the law. There's a best interest standard across the board, but they are adopting an old narrative that uh, has to be argued against on a regular basis. I think it's real important. I can't stress this enough. Nothing is more powerful than a judge in a family law courtroom. I don't know of another area where a judge has more authority, more power from start to finish than a family law judge. There's a quote that I like to reference from Roscoe Pound. The powers of the Star Chamber were a trifle in comparison with those of our juvenile courts and courts of domestic relations. And I think that's so true, because family law courts routinely separate children from their parents. Parents have done nothing wrong. They may ignore due process. They may silence dissent. They may not give a fair consideration to the evidence that's being presented, and they're taking children away from parents. And that can happen. And so no judge has more power over a case than a family law judge does. And so make sure to try to, we have a lot of good judges out there, a lot of good family law judges that want to do the right thing or trying to do the right thing, that educate themselves on the science, on the data, on literature that's coming out more and more, that stay up to date. And I hope that if you're in a jurisdiction that values your family law courts, that emphasizes family law courts, that you're getting the benefit of that. But in a lot of jurisdictions, you've got judges who are also, tomorrow they're going to do the criminal docket. The next day they're going to do a civil docket. The day after that, they're doing guardianships and probate. Family law is not something that they do every day. And so sometimes you have to educate them a little bit more. And that's where you as the attorney have a responsibility to make sure that you're doing that. And so if you're a litigant, if you're an attorney, if you're a psychologist, if you're a guardian ad litem, you may need to make sure that you're educating the court more than what you have. Which brings me to attorneys. Attorneys have got to take responsibility for the allegations that they're making in their pleadings. If you can't support those allegations and you're making them for a strategic purpose only, you are perpetuating a broken system and a broken process and furtherance of an unsupported narrative. And if you are an attorney who's making an allegation, I hope that you are supporting it and verifying it and making sure that you have the facts to support that allegation prior to making that allegation. You're not just hauling off and filing it because the client says so. Make them prove it to you. One of the things that I really like to do in my client meetings, and it's when it's in my office and nobody else is around but me, my staff, and the client, is to make sure that I have really pushed the client to the point where they don't like me at that moment, and made them and tested those allegations and made them really try to establish and show me, whether it's text messages, whether it's recordings, whether it's video, whether it's photos, whether it's their experiences. I really test those allegations before we make them. And that's probably why we don't make very many. We don't have a lot of cases where we make a lot of allegations, because you got to get over the hump with us before we're going to put them in front of a courtroom. And I hope other attorneys are doing the same. I'm not saying we're doing it perfect, but I hope that attorneys will take the responsibility for the pleadings that they're filing, because their name's on it, and make sure that you are not just filing it for the sake of leverage in the case. Guardian ad litems, GALs, are very common throughout our system, through our family law system in various states. In many states, they have become so common that if you have a custody case that's disputed, judges are going to order a guardian ad litem in the case. You may call them something else, maybe an attorney ad litem, but attorney for the child, whatever it is. But what I challenge, and where the responsibility in this conversation can we point to the GALs, is that if they are not doing the same, if they're not testing the allegations, if they're simply rubber stamping the allegation because they like that party better, or that party has a more emotional response, or there is some, they like the attorney for that party better, or they have more cases with that attorney. I hope that we don't have any GALs that are doing that. But GALs are there as fact finders. One of the things that we are really struggling with, I think, in our system, is what the role of guardian ad litem is. Some states have passed laws that prevent the guardian ad litem from giving a recommendation. Some states have recommendations. Some states just want the guardian ad litem to report the facts and not to give recommendations. It's not uncommon for GALs to overstep a fact-finding role and to make a determination, and then they just say, well, that's up to the judge to decide in the end, but my thought is this. Okay, so there's some responsibility there for guardian ad litems to challenge alienating activities, challenge alienating actions by a parent, and to educate themselves on alienating conduct and what parental alienation really is. If you're a guardian ad litem that does not believe that there is such thing as parental alienation, then I think you really need to do some education on the topic. And like I said, we're not talking about a noun, we're talking about a verb. Parental alienating activity is what we're talking about. And we're not talking about syndrome. I want to take syndrome off the table for this conversation, because that's not what we're talking about. We're talking about activity. And if you are rubber stamping the activity and you're not challenging the activity as a guardian ad litem, then you're contributing to this activity. So because you're an arm of the courts are doing the same, there's plenty of blame to go around there. And so, but as the attorney, as the litigant who's working with the guardian ad litem, sometimes you have to educate the GAL. If you have a state that requires the GAL to testify, in Oklahoma, we have the right to cross-examine a guardian ad litem. I like to make sure that I'm putting education material in to the correspondence that I send to the guardian ad litem, and then I can question them about that correspondence later when they're on the stand. That gives me an opportunity to get something in through that mechanism as well. And so if you have a guardian ad litem that's just not listening and not going to give you the time of day on these issues, send them a letter, send them a detailed letter, attach the literature that you're using, attach the studies that you want to cite to. And if they get on the stand and when you're cross-examining them and they say, well, I didn't read them, then there's a good opportunity for you right there to exploit that in the trial. Okay, so test your guardian ad litems, your GALs, test them, educate them, and hold them accountable. And don't be afraid to hold them accountable. The same for psychologists. If you are a psychologist or a mental health professional who is seeing children in the case, and you're going to testify in the case, or if you are talking to the guardian ad litem, if you're going to ignore the common sense elements of parental alienation activity, you may say, look, there's no such thing as PA syndrome. Nothing in the DSM-5. The DSM-5 is my Bible, and that's what I look at, and it's not in there. And so you may be one of those mental health professionals, but if you're ignoring the verb, the parental alienating activity, the actions, if you're ignoring that, then you're contributing to that behavior. If you're identifying it and you're identifying it to the guardian ad litem and you're identifying it to the attorneys involved, then you're helping to try to eliminate it. But if you're not, then you're only contributing to it. And there's blame on at your feet right there. Don't ignore psychologists that do not want to acknowledge parental alienation. I really would, if you're a practitioner, obviously you don't want to use them as a psychologist in the case. And so there are plenty. One of the things that I'm really happy about is, and a lot of them are speaking at this conference, but we have a lot of experts who are qualified and they're capable of coming into cases and testifying on parental alienation and the activity. And so I hope that, you have an opportunity to work with some of them, or you have someone local who's also qualified. All right, so we've talked about where's the blame to go around. We've talked about court schedules. We've talked about dockets. We've talked about judges. We've talked about how they manage and how they handle these cases. We've talked about the fact that attorneys have a responsibility in these cases to not perpetuate the alienating activity. We also have talked about GALs, and we've talked about psychologists. There's one other group that I want to reference, and I'll point you to another presentation I did for Families Divided, but that's church and faith groups. There is no question in my mind that there are certain groups of faith who contribute to a family law case becoming more contested, becoming more divisive, and dividing families. And what I mean by that, and I won't go into it in detail because I've already done a presentation on it, but if you are in a conservative church group that requires a showing of domestic violence, or requires a showing of infidelity in order to support the divorce itself and to support one of the party that is going to stay in the church, maybe both of them are going to stay in the church, maybe one of them wants the other one to leave, so they make an allegation of abuse. You have a role to, again, don't rubber stamp the allegation. And I think that's what I really want to test is don't rubber stamp the allegation. Don't perpetuate a system by encouraging more allegations of abuse, by encouraging a narrative that the other party is a bad actor, the other party is a bad parent, the other party is someone who doesn't need to have these kids. And too often churches as a support group often get involved in ways that will hurt that process and will hurt the process of reconciliation when it comes to parent and child, and will contribute to the alienation. I will say this, as we talk about this issue, parental alienation, I think it's important to understand that it's become a more prevalent issue in our day and age because the narrative, or there's been so much change in our family law court system. The dynamics have changed so much over the last 30, 40 years. With the introduction of no fault divorce and the movement to expand the opportunity for divorce for women to exit marriages, and you can go back and you can research that and this, but there was a movement, and it really contributed to women being treated equally as it relates to their ability to seek a divorce and to seek support moving out of that marriage, which is a good thing. It's not a problem. Nobody should object to that. But what that did is that we now see that 70%, 69.9% of divorces today are filed by wives. Okay. 70% of divorces are filed by wives. And as a result, they're filing that first pleading, they're making the initial allegation, they're setting the tone for the case in a lot of ways. As I've said in other presentations, you can go back and look at some of the other presentations for Family Divided, the father's role is not, we're not seeing a corresponding treatment for the father, as the father's role in the lives of the children has also increased. During the 70s, 80s, there was this cultural meme that dad was focused on going to work, coming home, eating his dinner, tucking the kids in, giving them a kiss, and going in and pouring a cocktail and reading the paper. That's not the reality of any husbands and fathers I know today. as the number of moms working outside the home began to increase, there was also a corresponding increase as far as the domestic roles of men within the home and with their children. However, family courts haven't evolved as quickly. I can prove it. Fathers, you've heard me cite to this number if you've listened to me. Fathers' time spent caring for their children has risen over 2 decades. It was 2.7 hours per week in 1975. It went to 3 hours per week in 1985. And then from 1985 to 2000, the amount of time went to 6.5 hours. So from 1975, 25 years, from 1975 to 2000, the amount of time that fathers spent with their children more than doubled. Yet the time that they have been able to, the time that they get with their kids after a divorce has been filed, has not gone up at the same rate. And so dads are spending more time with their kids, with their children, than a generation ago. However, our courts have not adopted the same kind of thought process that, dad is just as important as mom. And I'm going to start from that perspective. It would be so much easier if, when you filed a divorce, you knew that mom and dad were going to get equal time, that you were going to start from that place and you had to work backwards from there, instead of starting from the opposite place and having to work to get equal time. It would be so much better. And I think you would also probably see less divorces, but that's just me talking. We're fighting a presumption and a stereotype to some extent. And when we talk about there's plenty of blame to go around for this parental alienation issue. If you are already of the mindset that dad is not as important as mom, that dad can go over here and he can work, he can provide a child support check, he can see his kids on the weekends, he can, take them to see a movie, like I said, be a donut dad, that is not going to contribute to testing these allegations as they come up, because you're going to believe it. Okay. So, and that's where we are, I think, as a society today. So to wrap up where we're at, throughout this process, I think what you've heard me say is that the delays that occur, okay, in the end, the delays endemic of family law courts are resulting in deprivation of one parent. Most of the time it's the father. And research has shown that dad deprivation is a leading cause of over 25 social, psychological, academic, and physical health problems in children. So to summarize that, if you are a judge, if you are responsible for a court system, if you're a legislator, if you are passing laws, and if you are looking at what you're going to do, what you want to do to help future generations in your state, what you want to do to help families, then treat both parents equally. And you don't have to have a legislature tell you that there is a presumption that mom and dad should be treated equally. That should be the presumption, because that's what the data says is in the best interest of the children. And we have a standard that you should act in the best interest of the children. And I just told you that if you take one parent away, research is clear that depriving that child of that parent, especially dad, leads to over 25 various health problems. So, solutions. Let's talk about solutions real quick before we finish. Again, what I just said, presumption of equality for both parents in all respects. This is something that I think the time has come. We're in the place where I think we can do it. I think that states across the country need to pass presumptions of equality for both parents in all respects. I think standard visitation schedules should start at 50-50 and work back from there if there's a basis for that. That's step one. Step two, we have to create timely hearings on accusations of domestic violence. And what I mean by that is that if there's going to be an allegation of domestic violence in a family law case that's going to keep children away from the dad or the mom, then a hearing needs to be conducted very timely. Okay, maybe it's 60 days, maybe it's 90 days, but you need a backstop. You need a hearing on that, because if there's no evidence of domestic violence, you don't want that domestic violence allegation contributing to the case and how the case is conducted over time. And that's what's happening. They keep this trigger, keep this gun pointed at the other party, saying, look, I've got this domestic violence allegation, so I'm going to keep this pointed at you until you do what I ask you to do. And that is power and control by way of litigation. And then expedited hearings. At any time there's less than equal time, we should have expedited hearings. Okay, expedited hearings when less than equal time is entered in temporary orders. There should be a preference for custody cases in family law courts versus no custody issues at hand. If there is a custody issue or visitation issue, that case should be bumped to the front of the line. And someone who's trying to divide a business and that's the only thing they've got to do, put them at the back of the line. We get bumped in family law cases in Oklahoma County. We recently, our family law judges recently took over the adoption and guardianship docket. We get bumped all the time in favor of adoption cases. And so why would we not be able to bump litigants who are not dealing with a custody and parenting time issue in favor of one who is, to get those relationships back on track? And so those are three things that I think are very critical to moving forward in this with this issue. And I think that, as I've said, if you look at the system contributes to the parental alienation. A party who is trying to alienate a parent does not do so without some assistance throughout the process, whether it be a blind eye from a counselor or therapist, whether it be a blind eye from a guardian ad litem, whether it be delays in the process from the court system, whether it be attorneys not expediting the case. That all contributes to the alienating behavior, which results in the noun. We're talking about the verb resulting in the noun, and the noun being the syndrome. And you've got kids who don't want to go see mom or dad. We have to do better in this country. We have to be conscientious of every element of the process that contributes to this narrative and contributes to this issue, because if we don't, it's just going to keep getting worse. And we don't want to get to a point where we look back 100 years from now and our ancestor, or the people who come after us, look back at their ancestors and say, what in the world were they thinking with these family law courts? What was this? And so that's what we want to guard against. And I think that we continue to be conscientious of the issue. We continue to look to states that are doing it well and ask for help. And we continue to just keep working towards it. One of the things that I think is we have to be careful of is we just put it on the back burner and we don't address it. We have to keep working to get better. Courts are the same way. Lawyers are the same way. Judges are the same way. We got to keep getting better. And so I hope that happens. I'll leave you with a quote that scares me a little bit. Charles Dickens. The empty court is locked up. If all the injustice it has committed and all the misery it has caused could only be locked up with it, and the whole burnt away in a great funeral pyre, why, so much the better. We want to make sure that we're not continuing to exacerbate Charles Dickens's assessment of our court system. And so I hope that we work towards that and we can do that. So I appreciate it. I appreciate you paying attention. I appreciate you being here for the conference. I hope you've gotten something from it. If there's anything I can do, my contact information should be available. And I'm happy to help and to talk to anyone that I might be able to assist.